Yes, so welcome back, everybody. I'm astonished and impressed that we are not behind our schedule. We are even 4 minutes ahead of it. Thank you very much for that. And so we will continue with our session and start always the same topic and start with Dominik Wolski of Katowice School of Economics. So we get more economic input, hopefully. And
okay, thank you very much. Thank you very much, Mr. Chairman. Thank you very much, Umberto, for inviting me to this interesting venue. And I'm going to speak about the Polish legal reality, addressing to organized ski areas. Okay, let me give you briefly what I'm going to speak about. First, the short introduction. I'm going to give you facts, figures, and a little background of the safety issue addressed to organized ski area in Poland. Then the legal frameworks, let's say the law in books, where I'm going to speak about the main duties of operators, of ski area operators, as well as the main duties of ski area users like snowboarders or skiers. Then I think the issue which I find crucial when we try to specify, or when we try to limit the ski area operators' liability for safety issues. I mean the character of legal relation between the ski area user and ski area operator, and between the skier and another skier. Then the principles of liability. At this point, I have some reflections also against the background of the Swiss or German legal frameworks. And before conclusions, I think something which is the most interesting for me, as I find as the law in action, means the case law, how the Polish courts finds the cases based on ski accidents, what kind of decisions they made, and also what is the approach of jurisprudence to the, for example, to the issue of principle of liability in Polish law. And then a few conclusions. A few facts. Yes, I think are also the similar regulation on the similar law as Italy. We are, I think, a little bit exceptional country. Yes, that we have the law directly addressed to ski area operators or to the organized ski area. As in Italy, this law has been mentioned also by my Polish colleagues in our session before lunch. But we have also the law, which I can call that it is indirectly addressed to the ski area operators' liability, means, of course, the civil code and the principles of civil liability, the contractual and the tortious regime. The number you also could see in the presentation of my Polish colleagues, 2.8 skiers. I'm not sure whether this is a number of Polish skiers on the Polish slopes or in total the Polish skiers. Practicing skiers. On the other hand, we also have to take into consideration that this is based on declaration, yes, without any reference to the skills, to the frequency, and this is very important, I think. I also find some data about 5 million of Polish skiers, yes, which is, I think, if we compare this number to the number of Polish citizens, close to 40 million, is by the way, the significant number, yes, the 5 million of skiers. Of course, the accidents happen also in Poland, but I think we have the problem, which has been mentioned also many times in the session before lunch. We don't have any accurate data about the accidents based on the ski accidents, about the cases based on the ski accidents. But of course, every court in Poland has the website, has its own website, and then we can go and get some data about the particular decisions. But there is no comprehensive data, no data about the total number of ski cases. So this also means that we have problems with specifying the scale of the problem. Yes. For example, the ski accident. I'd like to speak briefly also about the Polish Act on safety and rescue in the mountains and in the organized ski areas. We have since 2011 this law. Mainly the law is addressed to the ski area operators and the ski area operators' duties, but also to the rescue services. And the first part of the law is addressed to safety issues in the mountains at all. It's not only to ski areas. What we can find in the Act, the first part is similar than Italian Act. We have some definitions being used in the next parts of the Act, like definition of the ski area operator, which is called in Poland the entity managing the organized ski area, or the organized ski area, or piste, or accident, or ski road. We have also some duties on the size of ski area operator, as well as imposed on the skier and snowboarder. And we have a specific part of the Act which regards mountain rescue services in the organized ski area. Based on this Act, Ministry of the Interior issued 4 regulations. 3 of them was mentioned before. I just to draw your attention to the last is the regulation on the grades of the avalanche danger. But since just one Polish area, organized ski area, is in danger of avalanches located in Tatra, the significance of this regulation in relation to organized ski area is not so important, it's not so high. And of course we have civil code. There I'm going to speak more about the rules of liability, or the regimes contractual as well as tortious based on the code in the next part of the presentation. Why the civil code is so important in the Polish reality? Because paradoxically, we have a really detailed Act on safety issues in the organized ski area, but there is no legal sanctions in the Act. Yes? So this means that even if the organized or the operator does not observe the rules coming from the Act, it means nothing in the view of the public law, of course. Yes, that's why the only measure to impose or to get the compensations is based on the civil code and the civil proceedings. As I said, we have two groups of duties. The first one is imposed on the ski area operator, which is, I think, also similar as in Italy, obliged to provide the proper safe conditions in the organized ski area. And this general rule of liability for safety is developed also in particular duties, as you can see. Speaking briefly, it's about marking, about signaling, ensuring rescue services, or informing or facilitating also for disabled people. Yes, a few particular duties imposed on the ski area operator. But when we are talking about the safety issues, in fact, the main rule is the obligation to provide the safety conditions for skiers and snowboarders in the organized ski area. We have also, and this is my, I think I find it well that we also in the Act address directly to organized ski area the liability or the responsibility for safety is balanced between skier and snowboarder, because we have also, as you can see in the slide, rules addressed to skier and snowboarder, and this is the same way of developing these rules. We have the general rule, everyone is obliged to act with the due care in order to protect her or his life, and also the life of the other people staying in the organized ski area, which is from the, let's say, civil point of view obvious, yes. And the general principle is also developed in particular duties, like, for example, the skier must be aware of the rules existing in the organized ski area and must follow the rules. This is one of the, or the other obligation is the obligation to inform about every ski accident happened in the ski area. Those are the main obligations, the main rules addressed to safety issues in the organized ski area in Poland. Now we have the main basis of how to enforce the rules. As we have two regimes in Polish law, and I think these are two key factors when we try to assess how far the liability of safety for safety of ski area operator goes. We have to go to the character, the type of legal relations between skier and ski area operator, whether it is contractual. If contractual, what does it cover? Yes, that's the key question. I think it has been discussed also in Italian reality, whether the safety issue is under the contract or not. And also, of course, we have to apply the tort regime on tortious regime in certain cases. In Poland, I think that also in bearing in mind that the court's decision, the situation is quite clear. The contract, once the skier or snowboarder bought the ticket, the contract is concluded. And the contract covers not only transportation obligation, but also proper conditions on the slope, and also the safety issues based on the Act on Safety and Rescue in the organized ski area. The other thing is that this kind of contract is also recognized as the consumer contract. I think we are going to speak also about more further. And this, I think, is, and this is the reason why the contracts between the skier and or snowboarder and ski area operators has been audited by the Polish Competition Authority a few years ago, in order to specify whether there is unfull clauses or not in this kind of contract. And then we have also the tortious regime, but the tortious regime is being applied only in case of accident. Normally, it doesn't exist. Yes, if two skiers collide or there is a other kind of injury on the slope, then we have a tortious regime. The next important issue has been discussed also today is the principles of liability on which the liability of ski area operators, but not only, also the ski area user or skier is based. In the Polish reality, we have so-called principle of guilt. So this means the fault-based liability. And in the vast majority of the cases, this kind of liability should be applied. This is the first rule, irrespective of the fact whether it is the relation between skier and snowboarder, or skier versus skier, or skier versus ski area operator. We still have this principle of guilt, but we have, based on presumption of fault, this is important, that the defendant must prove that there wasn't any negligence, that then there wasn't any fault, otherwise it has liability. Yes, this is the rule also in Polish law. And we have what is also, I think, important, two measures of due care, because the fault is based on due care. One is the standard, the ordinary due care, which is applicable to everyone. And we have also the professional due care, and I think that the second one, specific business activity, I think one of the examples is ski area operators activity. There is no doubt that some kind of professional activity. We have also in Poland, of course, principle of or strict liability, which we call in Poland principle of risk. But on the contrary to what I've heard, we don't have a general rule of strict liability. We have just a few examples in the certain provisions of civil code, or like, or the other example is the liability of tour operator in the Act on Tourism Services, where the liability in the Polish legislation goes farther than in the European directive, yes, surprisingly. So it's more restrictive for tour operators than according to the European directive. And also we have in the Civil Code Article 435, and this article can be applied to so-called dangerous activities. Yes, it is recognized as dangerous activities. Why? The precondition is that the dangerous activity must be powered by the force of nature. Yes, which is in case of ski area operators, electricity, yes, predominantly. So that's why this in many cases courts apply this Article 455 just to the liability of ski area operator. In some cases, I'm going to speak more about the cases.
Pending phase, because if it's because of the electricity, then it's only when, or it's all.
This is a tough discussion. To what extent the force of nature, in fact, powered the enterprise, and to what is, let's say, the supported, yes, only the supportive, the force of nature only supports the activity. Yes, the tough discussion about that in Polish law. What is important that only at least one of the three reasons, exonerated reasons mentioned in the article, can lead to exclusion of operators' liability. This is of course the force measure, the injured party's fault, or the fault of the third party that the operator is not liable for. This also means that, for example, for fault of subcontractor, the ski area operator is liable, is fully liable. Yes, there is no exception on this point. And now we move on, I think the most interesting for me, the part of presentation, because now we have the law in action. Yes, we can see here how those rules work in practice in Poland, how the courts recognize the liability of ski area operators. And being a little bit ahead of conclusion, I think that I must say that this liability is properly balanced between the ski area operator and ski area user, because mainly the Polish courts apply the principles of fault in relation to ordinary accidents, yes, when we have this one skier police the other skier, and also when this is within the organized ski area, but this is not attached to the infrastructure, this is not in any relation to the infrastructure, then we have the principle of fault. But when we have an accident which is related to infrastructure within the organized ski area, then the strict liability is being used by the court. This is I think if we go to the judgment, this is the clear distinction between the infrastructure cases and or injuries and let's say ordinary accidents. The other thing is that also courts state clearly that everyone is obliged to due care when skiing or snowboarding, and it also goes without saying that there is no strict liability in the line between the ski area operator and ski area user in ordinary cases. In ordinary ski cases, there is no one case not observing this rule. What I can say more also about the law in action, about the Polish court's approach to the problem of ski accidents. Polish courts really welcome so-called out-of-law factors. Yes? So that's why I say that this is the rule of reason principle. Yes? This means, first of all, the FIS decalogue. Yes? The Polish courts find FIS decalogue as the code of conduct which should be used in every organized ski area, and this is in practice. This happens in practice. In fact, in the vast majority of Polish ski area services, the FIS rules are attached, being a part of the contract concluded with the skier when he or she buys a ticket. This is also very often, what is also very often used is this is the assumption of risk. So we could see it today, yes, the assumption of risk, meaning if you decide to use such a risky sports like snowboard on skiing, then you must be aware of the risk. So this is not, this is also the conclusion coming from the court decision. Even more, there were a few cases where when the conditions on the slopes were really difficult, yes, really difficult, and then also the court said that, of course, if the conditions are extraordinary, then you have to make effort, then you have to, being a snowboarder or skier, you have to make more effort to observe the rules in order to protect your life and health. So this is also not the reason for extending of operators' liability, even the difficult conditions. And as I said, the last but not least is that the Polish courts use the rule of reason in its judgment. Yes, so that's my opinion that this risk is properly balanced. This brings me to three conclusions. First conclusion is since we don't have any effective legal instruments in the Act on ski area operators, we have to rely only on civil liability, and in spite of many duties, many obligations imposed on very detailed sometimes imposed on ski area operator, some of them are not observed. Yes, it's obvious, like the register of ski accidents. These are a lot of problems with how to get the information, the accurate information about the number of ski accidents, since we don't have any source. As we spoke before a few minutes, it's some kind of PR, yes, that I say. How many accidents occurred in my ski area? Yes, if it's too many, maybe this is not an advertising. It's so. The second conclusion is that mainly the liability of ski area operator in Poland is based on fault-based liability. This rely on fault-based liability, and also the last. My conclusion is that the risk between ski area operator and ski area user is balanced in a good way, in my opinion. Of course, this is disputable, but from my point of view, it's balanced properly. Thank you very much.
Thank you very much, Dominik Wolski, for this further information on the situation in Poland. It is now my tremendous pleasure to announce, to offer the floor to our chief organizer and to our head of this workshop, and possibly the head of further cooperation between us on these topics. So I think I don't have anything else to say, Umberto. Just give you the floor, and thank you very much.
Well, thank you to you indeed, Thomas. Thank you to all. Let me state clearly again that I really appreciate your being here. I mean, you accepted my invitation this summer, and it's very nice to see that a summer thought has become a winter reality. So let's start with some data about the Italian. Let's start with some data about the Italian report. First of all, I must say that contrary to what I've been hearing so far, in Italy we have a source of direct analysis of the case law, because I've been with other friends, but in Trento we've been collecting a few years ago 35 years of case law that was silently recorded in the court, and we have brought all this case to public fruition. So we now have a database that can be, of course, this is in Italian. We have done not only you can have access to the integral text of the decision, which are criminal and civil, but also there is the maxims and the comments. So if in the site, the website Diritto degli Sport del Turismo, you can have access to this source. And I can say that we have collected more than 1,000 cases. So empirically, this means something, at least. From the point of view of the official statistic, we used to have a wonderful system of surveillance of the accident rate in Italy. It lasted only a few years after the enactment of the law of 2003 that I will shortly introduce to you. So the last official statistics are for 2007, and they say that basically out of 55 ski resorts monitored by the police, we have 35 accidents yearly happening in a cohort of 2.5 million of alpine skiers, 500,000 snowboarders, and backcountry skiers, 400,000. An interesting data is because we've been looking this in other presentation, the collision cases are 12%. But I've been, since I was doing this workshop, I asked to the police the Italian police to have access to their hidden databases, which is a sort of treasury box, because they all have this, incredible resources of data, but they never publish this data. So this is the first time that I can be able to present publicly some data. And they have an incredible detailed database that I've been querying in these past weeks. And so we have a database made by 15 years of intervention of police on the Italian slopes. We have 216 cases, cases of, or even more, of intervention after an accident occurred on the Italian slopes. So a rather large, I would say, statistical base. And what I was looking for, I was curious to know what's the incident of the nationality of the victims. And here is the finding. The finding is quite interesting to me for the sake of this workshop, because we have almost 30% of the victims of accident occurring on Italian ski areas that are foreigner. Of those, 24% of the general are EU member tourists. They clearly are tourists because we are talking about Italian slopes. So this, I think, it's very interesting data about the importance of analyzing this issue in a transnational dimension. Oh, yes. So other interesting data of this database are, I will come back on this, the fact that, as you can see, red slopes are the most dangerous slopes. And this is quite odd with the conventional wisdom, but of course there is an explanation. The explanation is the cognitive factors. People on the red slope think that they are easy, think that they are relaxed. They probably also are on the phone maybe while doing the ski area, and they get injured. And you see, this is very important, and we have to think about these cognitive factors when we consider the issue of civil liability on the slope. And for the rest, I don't mention the other, but of course. Other data are the presence of helmets. We have been introducing the mandatory helmet provision for under 14 years old in only 2003, and the reporting of the boxes with or without helmet starts only from 2007. As you can see, so it's not a statistical base, but there is an increasing range of people that it's injured people that it's wearing a helmet while after the accident. And then we have 18% of snowboarders victims and 82 of skiers. More or less, we are in the other data of other national reports. A brief history of Italian ski law. Ski law in Italy starts in the 60s, like in most industrialized nations, as an industry. In the 60s, of course, there is also the formation of the FIS rules, which are not positive law at all since the inception. They have been elaborated by a community of legal, unprofessional, let's say, non-academic thinker who were having conference in the 60s. And these rules have been basically used by the Italian case law from the 60s onwards as the binding rules for the circulation on a slope. Then we basically, for skier collision, we have the general clause of our tort law applied to Article 2043. There have been attempts in the very beginning to mimic the idea that circulation on the ski is like circulation on vehicle circulation, but the idea was rejected by the case law, the Italian case law. So Article 2054, which provides for the case of vehicle collision, was never applied to circulation, to the circulation on the ski slopes. Not even the 2050 provision of our civil code, which is the dangerous activity rule, which stated basically you are responsible unless you produce evidence that you've taken all the precaution that you can. It's a very, I mean, quite. We heard this morning and even this afternoon some similar provision in the other civil code. So this for what concerned the case of collision. With the SAO, so I call it SAO, the ski area operators, they basically, of course, in the lifting phase, downhill, uphill, were held under a contractual liability standard. And we have a special provision of our civil code addressing the contract of transportation or carriage that states clearly there is an obligation of safety, obligation de sécurité dans le contrat de transport, stated in our civil code. So basically, in that case, it's a very strict liability. It's difficult to get rid of that kind of liability. So, of course, there has been a case law questioning if you are still under the energy of the transportation, but that's small detail. So this is nothing has changed, and in this respect, on the uphill phase, we are clearly under a contractual liability. But at the beginning, the Italian court refused to apply the same standard to the downhill phase. It was only later than this became more common. From 1990, there was some territorial court stating the possibility that since, of course, the contract of transportation, you take the skill of, not for the sake of a real or just that transportation, but of course you are putting into the economic of the contract also the idea of descending. So there was an elaboration that brought eventually the Italian court to state that there is a typical contract that covers up and down, and this contract must be reconstructed in terms of rule of liability. I'll come back on this. Other rules that have been applied also, it's Article 2051, which is the basically responsibility du fait de la chose, standard. Only you escape from liability only in case only if you produce evidence of force majeure. But this applies to the custodian liability. It's not fait de la chose, but it's liability for custodians. And it's controversial. There have been several applications of this standard to the downhill phase, but there is a controversy about this because the idea of custodian to be in charge with the strict sense implied by the rules of the slopes that are so large and under natural elements is questionable at least. But the ski pass contract is on the rise in Italy nowadays. Regional regulation. In Italy, from 70 onwards, we have been witnessing a spontaneous rise of regional, local regulation, starting from the Regione where we are here, in Trento and Bolzano, was the first. And then we have been having at least we now have 14 different regional regulation administering a very specific rules concerning how to, public law aspects, authorization, obligation, technical norms, and they all differ. There is no uniformity as to many important aspects that then come to be have a very important, a great deal of importance when judge apply these rules to the cases. So there is this kind of what I call the Babel maze of the regional regulation, and also concerning the ownership, public versus private, it's mostly private. Only Val d'Aosta, the French autonomy region close to the French border, they decided a few years ago to enter as public actor into the business, and basically they are administering their system of ski areas as a region. But mostly in Italy, the region that are marked in black are where there is a substantial business of ski areas. It's Lombardia, Veneto, Trento, Bolzan, Friuli, and Abruzzo in the Apennine is also an important place. They have privately run ski area operator with an important, of course, public participation in terms of financial contribution. That it's the object of a big debate, of course, because it's not clear the framework of how this happened in different regions. Then Italy in 2003 marks a specificity in the European context because we, as you probably know, we have enacted this specific law addressing the idea of safety and liability specific for ski area. This was after there was a bipartisan attention in our arena, political arena, because left and right were okay with this new regulation because we had very bad accident in 2002. So it was a sort of also an emotional thing that brought this law in force. And this law starts with Article 1 that say, we want to do this, we want to improve safety for the sake of encouraging the development of economic activities in mountain areas. So the link, if you want, of this idea of this workshop comes also from the inception of this act that says more safety for the sake of economic, flourishing economic mountain areas. And this law introduced the notion, the legal notion, as in the Polish case, of ski area. Ski area are defined as equipped ski areas, snow-covered surface, even artificially open to public and including slopes, ski lift, snowmaking equipment, usually reserved for the practice of snow sports such as skiing, snowboarding, cross-country skiing, sledding, and sleigh, other sport identified by every single regional regulation. This, the entry into force of this definition made clear that there was no way to escape from the idea that the contract must be, as I said before, the ski pass contract covers the up and the down. So we have a legal definition of ski area, and so basically this provision makes now applicable to the litigation between skiers and ski area operators, the very severe regime of contractual liability. I've been listening to the French and also the Spanish experience. You all have the possibility to play with that incredible trick that was Demog invented several years ago about obligation de moyenne and résultat, which enables you to really capture the sense of what is the content of the contract obligation. In Italy, after 2001, we had the Supreme Court deciding that contractual obligation means the reversal of the burden of the proof. Defendant must prove that a foreigner cause was the cause of the breach of the contract. If you don't do so, the plaintiff will prevail in a contract case. Applying this very general scheme to the case of ski area makes a nightmare for a ski area operator, as you can easily understand. So, increasing rate of litigation, so more legislation. Of course, the law 363 brings a lot of obligation on both for skiers and both for ski area operators. Eventually, the FIS rules have become positive law in Italy, with some important distinction. For instance, the fact that at cross borders, you have to give precedence to the skier who is on your right, which doesn't make much sense on the snow area, because it makes sense maybe in the circulation, but doesn't make in the traffic jam, but not in the snow area. And this also, it's important because, as you see, if a Polish skier or if a Belgian skier come to Italy and he's used not to give, for him it doesn't make any sense, this rule. And then in Italy we have a positive law, so not just the interpretation of the rule of the court, but the positive law that say you have to stop because someone is coming from your right. We have some problem in this. Of course, obligation. President Ghezzi went away, but she will probably say like this. If I talk about all the obligations that are imposed on the Italian ski area operators, which means eventually also more cost to sustain, and another important, so framing in contract the litigation between skier and ski area operator makes also available the consumer protection apparatus and legal consequence. And what happened in Italy is that because of the unfair terms in consumer contract, the European directive, as interpreted by the Italian Court of Cassazione, it made clear from 2003 that if you enter in a consumer relationship, and of course buying a ski pass means to enter in a professional consumer relationship, then if you claim the breach of contract, you can sue your defendant professional in your own court, which means that nowadays people from Sicily are suing ski area operators in Trentino in Sicily, and they hear the case in Sicily, and they need to have a delegation of the evidence. It's basically I know it sounds weird, but this is a byproduct of a general regulation that make perfectly sense if you apply to this field. It doesn't make sense in this field, but it's there. And I wonder, and I will be very keen to listening to what Thomas Calden will tell us about the prospect that this kind of jurisdictional switch will happen in to transnational litigation in Europe. Imagine people suing Polish suing who are injured in Trentino, suing in Poland, applying maybe the Italian rules to the case. It's a really a nightmare in terms of. So jurisdictional advantage for consumers, the need for Schiari operators to create a legal team that are able to defend the cases all over the territory. It's a big change. And of course, this also, that it's not good for economic procedural issue, like the possibility to discover fake witness. We know that on the snow, it's an event that can be taken in consideration. The fact that someone who is skiing with a friend, he falls by his own fault, and then he will witness that there was a icy condition that should have been removed by the Schiari operator. So the formation of evidence is crucial to our problem. And in this case, it's lost, because if you hear the case, you are in Palermo, you won't be able to, you only read written deposition and you don't understand. So briefly on this, there was this standard agreement that has been a Lombardy region initiative. It's in English, so the Lombardy region provides for their Schiari operators a model contract. And you can read this model contract because it has been translated in English, and it's quite interesting. You can, of course, I cannot enter into the details, but I think the contract in this, if we accept the idea that the contract is ruling the relationship between the skier and the Schiari operator, the contract can be seen as something that it's not against the skier, but it's or against the Schiari operator, but it's also an instrument for somehow overcoming some informational gap that there are between the parties. Because with contract, normally you have the general condition outside the ticket, no? So you never read those general condition. But nowadays, the more and more we are into the e-commerce, and you can choose from your the day before that you decide where to ski, you sign the contract electronically, and you get the general rules of the ski area. I think it's an interesting opportunity to be at least to be analyzed and discussed even at the European level, because this will also be a possible tool to overcome the fact that I don't think that the European authorities will set in place a regulation addressing our problem. So one way of looking to the uniformity could be to think in terms of standard contract that could be shared and, of course, processed by all the different legal experts of the community, but to provide a uniform sort of regulation. No, I've lost the. Okay. Oh yeah. Yes, there. So some. I wanna. I don't know if I'm running too late. Sorry for the time consuming my time. I want to do some general some thought about civil liability of Schiari operators. First of all, we should not trust the idea of strict liability. No deep pocket here. I think that to think in terms of deep pocket when we think to the relationship between the skier and the Schiari operator, it has the eventual meaning of destroying the toy. Because if we force Schiari operator to internalize all the costs and to act as basically as an insurer, the final result, and this is quite happening in Italy, could be that they go out of business. And if they go out of business, we lose all the economic importance of the sector that we have been listening this morning. So also we don't have to overlook the fact that, as I said, cognitive issue, the so-called lulling effect. Lulling effect means, when has been studied by cognitive scientists, when you are safe, when you feel safe, you tend to downplay your level of attention. And we all know that by skiing is made essentially of that attention. Even if you are a champion, even if you are Michael Schumacher, and you know very well how to ski, if you think it's easy, it's something that you can do it, your attention decreases, and the likelihood of an accident it's more possible. And also, when we construct conditions that make evident to the skier that everything is perfectly neat, clear, safe, what happens is that I wanna have the skier wants to recreate the sensation that brings the skier to be on the ski area. And the sensation seeking is the sense of challenging your own limits within a reasonable range, within a reasonable. If you create billiards instead of ski slopes, you will go faster. And if you go faster, even if it's perfectly safe, the ski area, the likelihood of accident increase. So there is this important, I think, factor that has to be taken into account. Very important in general is the souplesse of the final judicial product. The court must adjudicate the case, taking in consideration all the level of precaution the actors involved in the litigation have, and they have to consider this by using contributory negligence and with no automatic, not rules that create the automatic presumption of liability. Something should be done about this. Insurance issues, and now I come to an issue that I hope Thomas will find interesting, because
find it all interesting.
No, it's well, I'm talking about Article 19 of our National Act that talks about comparative negligence. Basically, what has been realized by this provision is the idea that if, in case of collision, and if we don't have evidence, then the court has to adjudicate the case, administering an equal share of fault between the two parties, which means that I always make this example to my students. If I meet Berlusconi on the ski area, and I'm a youngster, I only have a small equipment damage, and Berlusconi is 100% invalid, lose the control of his. What happens is that I will, because of this rule, the court cannot refuse to say we don't have evidence, so it's non-liquid. So I have to refuse the claim. No, they have to adjudicate the case, and they have to adjudicate by giving on the youngster half of the damage suffered by Mr. Berlusconi, and to me and to Berlusconi half of the damage of my equipment ruined. This means that what I call a half strict liability rules, because if you cannot produce evidence that enables you to prove that the fault of the other party, you are subject to a sort of strict liability-like final. And it's something that works well in the insurance, in the circulation of vehicles, because we are all mandatorily insured. But if you don't couple this provision with the provision stating the mandatory insurance, all skiers must be insured for the damage that they may produce to others, then this is really risky. You don't know this, you don't have insurance, you meet Berlusconi on the ski area and you're done. So sanctions, in Italy it's a public law, it's a carabinieri, police, by law, they have to be there, they control, so it's a great gift to ski area of the industry. They are responsible for this. I don't mention this recent case because it's a bit too late. I want to go up to the problem of defining the borders in Italy. In Italy, Article 17 of the law of 2003 states that basically outside the ski area, you are exempted by liability. But the problem is that there is no definition of what the ski area is, what the borders of the ski area are. And we heard that in ski, this excuse, and also in Austria, there is a clear toe limit, the 2 meters range. In Italy, it's not like that. We don't know exactly where the geographical liability of the ski area operator ends. Some regions have been providing a specific, more specific provision. Some others not. And a recent case happened in Lombardia, Tribunal of Sondrio. There was a Swedish skier, a tourist, who went into a ski wag that wasn't signaled. And this guy was, of course, severely injured, a billion euro of damage. And the ski area operator was regularly condemned for this, even if this was clearly outside the ski area, but there was no marking. There was no marking, and even if the accident happened very far from the ski area border, it was condemned. Finally, let's end this presentation with an example. Let's be into a living case. I don't know if this is the place where Michael Schumacher suffered in Meribel, the famous case, and we all know that in France. There was a discharge of liability, criminal and civil liability. As you can see, this is the area where the poor Michael went into his coma state. And I want to show you why, basically, there was no liability in this case. Because the poor Schumacher was wearing a technological video that was recording his ski. You can see Michael Schumacher is now skiing happily in a very sunny day, and you can see he's wearing the helmet. He's happily skiing, and then well, let's go on because it's It's still in the slope. It's perfectly in the slope. He swings around other skiers with skills. He's a very good skier. He's supposed to be a very good skier. And then you can see the condition of the slope. There is no marking here. I don't see any marking, clear marking in terms of the Italian regulation. But here, he decided to take this other route. It's still in the slope. I don't know if there is a marking, you can consider this slope marked enough according to the Italian, some Italian legislation. Yes, we are still in the slope. Yes, and then he will now decide to take. Okay. Sorry for this, but I think it's interesting. Then we, yeah, it's coming. Okay, here, look, he stops, and there is no marking here. I mean, I haven't seen any mark of this is the accident, the real accident. And see, this is out of the slope, but there is no palinatura. Of course, we have the video, so it's clear because we have the self-evidence of the video that tells us that he was deciding to go outside. But there is someone who already had. Okay. Okay. This example for the poor Michael to say that had this happened, has this accident happened in the what if Schumacher was skiing in Italy and there was no video and there was no marking in that case? I think that in that case the ski operator would have suffered a damage, had to pay damage to Schumacher, to all the family, maybe 30 billion of euro for damages in this case, loss of earning, loss of sponsors, disaster for medical of all his life. So the importance of this issue of the borders, because So handle with care. This is the final message. Of course, we have to be aware, we have to know more about this kind of litigation. We have to also consider the final paradox of all this, because in Italy, we have a specific legislation addressing the problem. We have invested a huge amount of attention to provide safety, so on, and now how we sell our mountains. If you go and check in the tableau on the street, it's free riding, go out. So we have created an environment that is super legally protected, safely, all the obligation, lots of cost and so on, but we appeal the people by saying, come to Trentino or Bolzano or whatever, because you do free riding, and free riding, of course, outside this. So back to the question, what's the driver of the skier? Why the skier decide to invest his money, his time, and his sense of vacation in doing this? For the sake of sensation seeking. So we have to consider all these elements when we will, and I hope that this will be possible in the near future. Thanks for your attention.
Thank you very much, Umberto, for this rich information about the Italian situation. I think the law 363 of 2003 really adds a particular feature to the European scene in our field. And I also learned from another of your statistics that if I want to be... It's probably not the moment to make a gag after this video, but from your other sheet I learned that if I want to be on the very safe side, I should ski on the baby slope with only 26 injuries over 8 or 10 years. Yes, so we now come to the third highlight of the afternoon, and we will now learn about the situation in the Netherlands and in Belgium, and I pass the floor on to Pieter de Tavernier. Thank you very much.
First of all, on behalf of myself and on behalf of Dirk Dielen from Belgium, who joined us at noon, I would like to thank the organization for this very interesting start of a new research project, bringing together a lot of countries. Maybe some countries are still missing, I think, for instance, of the Nordic countries, but that is a point of discussion for tomorrow morning, or maybe for tonight. My presentation will be a little bit different because I'm not from an alpine country. Neither Dirk is from an alpine country. We are from the low countries. And, but skiing and the skiing industry and the snow industry are relevant, both for Belgium and the Netherlands. And before starting my slideshow, I would like to tell you something about, for instance, the question about are Dutch and Belgians only skiing consumers, or are they also skiing entrepreneurs or snow sport entrepreneurs? Well, about ice skating, and I will show you a nice slide about ice skating competitions, there is definitely an industry. But you should also be aware that in Belgium and in the Netherlands, there are a lot of snow halls where you know, where on artificial snow, the Belgian and the Dutch youngsters and less youngsters can practice before going on holidays. And one of the actors in the Dutch artificial snow equipment halls is Snow World. And Snow World is actually one of the world's leading companies with regards to that industry. They are marked on the stock market, and they are now planning to build very big infrastructural works with regards to those practices, both in Paris and in Barcelona. So please follow that. So the Dutch and the Belgians are also present in that industry. This is a short map of the north of Holland. I'm going to tell you something about a case which was decided by Leeuwarden, by the Court of Appeals. So please keep this name in mind for the further explanation of my presentation. You know, the Dutch are known for that. They are known for the skating competitions. But the Dutch are also known, and we have just seen the accident of Schumacher, but you know, the Dutch and the Belgians became more aware of the consequences of big skiing accidents after the death after a long coma of the Prince of Orange, the son of the former Queen Beatrix of the Netherlands, who has been very long in a coma, about 1 year, and then he deceased. But he had no airbag. And the one who was with him in Lech in Austria, he had one, and he survived. And you can see a reconstruction video of that incident on the internet, on YouTube, from the Nordic television. There are a lot of skiing competitions also in the Netherlands, as you can see on this poster, Bergsenhoek, that's in Holland. You can also practice during the Christmas holidays in Holland, in Sassenheim, that's just 5 kilometers from my house. 3 lessons, 55 euros, before my skiing holidays in January. In Belgium, we have also our skiing champion, Seppe Smits. I will show you his CV, quite impressive. Special activities, snowboard, slopestyle, and big air. Slopes, on the second speciality, he won the World Championships in Barcelona. So you know we have also practitioners on a professional level. And Marcel Hirscher, finally, he is half Dutch, because his mother is Dutch and his father is Austrian. But unfortunately for the Low Countries, Hirscher decided to compete for Austria and not for the Netherlands. He won his first Super G very recently. But now let's become serious, because this is a serious meeting, and I would like to talk to you about the application of skiing law with regards to which were decided both in Dutch courts or tribunals and in Belgian courts and tribunals. And the lists are quite long. There is just a slight difference between the availability of decisions with regard to skiing accidents, and most of them are skiing collision accidents in the Netherlands and in Belgium, because in the Netherlands the case law is very well digitalized at the moment, so it is very easy to have access to the case law in the Netherlands. There is just one disadvantage for our group, because the case law is published on the internet in Dutch and not in English.
HTML, then you can use Google Chrome and you can...
Well, you can try and to find some elements of assessment. Yes, that's true. But also in Belgium, things are changing, and let's hope that the case law of Belgium will be quickly more available for us and also for the other judges, for the lawyers. So this is the first important slide. There are a lot of decisions, as you can see here, of Dutch case law in which the FIS rules have been applied. I've made here a list of decisions in which the judges make expressively use of the FIS rules in order to decide on collision cases. And some of the collision cases go about a Dutch skier who hurts a French skier in Germany, or a Dutch skier that had an incident with a skier in Austria caused by a Frenchman. So there is a mixture of all kinds of situations in the Dutch case law. Further on, I will develop one case, the case of Leeuwarden, because the case of Leeuwarden is very important in order to understand how the Dutch, some of the Dutch judges deal with the FIS rules. And there is quite a lot of there are quite a lot of differences between the court decisions. Some of the Dutch judges take the FIS rules very serious, and others do not. So there is not a very good high level of legal certainty about the use of the FIS rules in the Netherlands. There are also other issues which are dealt with in the cases that I have found via the internet. These are all cases about social security issues. I'm not going to develop them today because I want to stay on the main subject of the assessment of the duties of care, the application of the FIS rules, and so on. There is also an interesting case, and now I'm looking to my right side, in which the Supreme Court in 2001 had to make a decision about the application of the Hague Convention on the law applicable to traffic accidents. And that attempt was done by one of the lawyers in the case, a former colleague of me who is now active as a judge in the Supreme Court, Polak, but he failed. The Supreme Court decided that the Hague Convention on the law applicable to traffic accident of 71 could not be applied to ski accidents, yes. Let's now go to the Belgian courts. And I would like to mention some important aspects. And I have taken notice of some elements that have already been mentioned this morning and even this afternoon. And at the end of the conference, at the end of the workshop, we will certainly be able to categorize the different legal questions that have risen here during our gathering. And specifically, I would like to mention, for instance, the application of the duty of care, the application of the general norms of tortious liability, and so on. Well, let's just have a closer look to some of the Belgian courts. Well, in the Belgian courts, we see that the FIS rules, as such, are not named by number in the court decisions. But as we look to the case law in Belgium, we see that the Belgian case law applies the FIS rules. But the application of the FIS rules makes a part of a larger appreciation of the accident as a whole. So the judges in Belgium, they look at they demand if the FIS rules has been respected or not. But this is just a part of a larger appreciation of the duty of care due by the person who has caused the damage to the plaintiff, and is seen in a larger environment of the appreciation of the general duty of care. But I have here, for instance, a decision of the Tribunal of Brussels of 9 March 2001, published in Sport and Recht 2002. And as I can read this case, the FIS rule is mentioned explicitly without giving a number, but when I continue let's say, the decision of the judge, I can consider this decision as a good application of the FIS rule, but also in relation to the general duty of care due during the sports activity. But there are other decisions by Belgian tribunals, for instance, the decision of Brussels 10 June 2008 and the Tribunal of Liège 30 April 2010, where the general duty of care is very well examined by the Belgian tribunal without giving the number of the FIS rule that has been respected or not. In Belgium, there are a lot of international private law issues that are dealt with, and that's of course a normal thing, because we are of course in presence of cases where, for instance, a German skier was the plaintiff, a Belgian skier the defendant, and the location was in Austria. Or secondly, the Court of Appeals Ghent, French skier, Belgian skier, the defendant, and also his parents, and the location Tignes. what have we learned from the Belgian case law with regard to the international private law issues? Well, you have to know that since a couple of years, with regard to the competence of the judge, the Brussels I regulation is now applicable, and with regard to the applicable law, the Rome II regulation is applicable. So some of the decisions are legal history, because in those decisions still the old rules are applied. But I just give one example, which is quite interesting. The Court of Appeals, Ghent, 18 May 2006, was decided in Belgium based on the rules of international private law, and French law was applied. And I read the decision of the Court of Appeals Ghent yesterday evening for a second time, and I discovered something very interesting. And now I'm looking to my right side to the French participants. The Belgian Court of Appeals Ghent applied correctly the article about the strict liability of the parents, but incorrectly applied the rule with regard to the personal liability of the child. Because we should all know that in France, according to the case law of the Cour de Cassation, and according to the Funiviari jurisprudence, children, independently of their age, can be held personally liable. And the Court of Appeals of Ghent decides the child cannot be held liable because he has not yet come to the age of intelligence or of reason. So, incorrect application of French law. Oui, mais ça peut arriver, ça peut arriver.
But it was a private international law case referring to French law.
Yeah, we'll discuss this. Take a note.
Of course, pour le dire en français, ce n'était pas dans le cas très important parce que les parents étaient tenus responsables, objectivement.
Ça va poser la question de savoir qu'est-ce que l'on prend quand on va prendre la loi applicable. Est-ce qu'il faut se soumettre aussi à l'interprétation du cours de cassation qui est contestée même en France?
Well, that brings me to the second point. I still want to deal with some interesting questions of private international law. But for that, before doing that, I would like to tell you something about these three decisions you see in front of you. There has been a discussion, and there is still a current discussion about the fact if a skiing accident should be treated as a traffic accident. Well, there is still discussion because I've read the Supreme Court, the Hof van Cassatie, Cour de Cassation, is approaching it in a very, let's say, is hesitating about the issue, but there has been decisions telling that a skiing accident is a traffic accident, and that on the basis of the Code de procédure pénale, the cases should be brought for the so-called Tribunal de Police. And that's a criminal court which is exclusively competent for traffic accidents. But this is still a running, a current issue. About the assumption of risk, I'm not going to deal with this in detail. You will see that and read that in my paper. But now I would like to come back to the Netherlands, because I still have to deal with the case of Leeuwarden. And that deals also partially with international private law problems in Belgium. You know, both with Brussels I and with Rome II, both parties, the plaintiff and the defendant, can use those instruments in a very creative way. And it is, of course, very important, both for the defendant and for the plaintiff, to know where the case will be applied and which law will be applicable. Because the FIS rules, by some Dutch courts and by some Belgian courts, or Belgian tribunals or Dutch tribunals, are applied in a different way. And for instance, when you bring a case of a skiing collision for a Dutch court, for instance, then it happens very often that the court will deal with the skiing accident as a sports accident that happens, for instance, in contact sports like football. And it is sometimes an automatism in the Dutch decisions that we read the following reasoning. And this is really a decision that all the students in the Netherlands know very well. It's a landmark decision. The participants in a sport like football must expect each other to commit actions which are dangerous to a certain extent and which are provoked by the game, while the participants in society need not expect from each other actions that give rise to a similar danger outside the context of the sport. Well, there are a lot of judges and in courts and in tribunals which have the automatic reaction to apply this rule on all kinds of sports. And this also happened in the case of Leeuwarden. The case of Leeuwarden was about two brothers, and they went skiing in Val Thorens. That's why I showed you the map of Val Thorens. And they were just skiing on a certain distance to each other, and suddenly a child comes from the right side to the left side of the slope. And the second brother hits the first brother. And the first brother is seriously injured. And the insurance company of the second brother sues the insurance company of the first brother. Brother A, brother B, insurance company sues insurance company of the other brother. And both the Tribunal of Leeuwarden and the Court of Appeals of Leeuwarden has just applied this rule. And so it could have been much better in this case for the victim, so for the plaintiff, to have made better use of both Brussels I and the Rome II regulation. Because when we read the, let me read these rules again. Article 2, subject to the provisions of these conventions, persons domiciled in a contracting state shall be sued in the courts of that state. So that's the Netherlands. But specific rule, Article 5 tells us that also the courts relating the matters to tort, delict, or quasi-delict in the courts for the place where the harmful event occurred. And the accident occurred in Val Thorens, so the courts in France could be competent. What about the applicable law? Let's go to the regulation Rome II. Well, we first start in France, but Article 4.2 tells us where the person claimed to be liable and the person sustaining damage both have their habitual residence in the same country at the time when the damage occurs, the law of that country shall apply. So then, of course, the defendant is in a comfortable position to see the Dutch, let's say, bad application of the FIS rules being applied. But then again, I think that the brother or the lawyer of the victim did not read very well the whole regulation, because in Article 3 we see a possibility to have, again, French law applicable. And then, of course, he would have been in a very better position, because in France the FIS rules are being applied in a better way with regard to the protection of the interests of the victim. And then we still have to refer to Article 17 and the consideration of 34 of the Rome II regulation, in which the lawyer of the victim could have found very strong arguments to see this case dealt with according to French law and not according to the Dutch jurisprudence or the Dutch case law of the Dutch Supreme Court.
Probably the lawyer wasn't a comparative lawyer. He didn't know French law.
Well, he probably was not aware of the fact that he took an enormous risk to go to Dutch court and not to go to a court, in this case, in France. Well, I found other interesting arguments with regard to this issue in the literature in Czechia, but also in Colorado, in the United States, because when you read the literature about ski collision incidents in the United States, there is quite a lot of literature about the differentiation between non-contact sports and contact sports. And when we read, and we have already mentioned that during our workshop, at the question, shouldn't we be able to make more detailed lists or rules about the question or the answer on the questions, what are inherent risks of the skiing activity and what are not inherent risk of the skiing activity? Well, in the United States, when you read the ski safety statutes, all the inherent and the non-inherent risks of the skiing activity are summed up or are mentioned much in detail. And this is, of course, a choice that the legislature in the United States have made in the 70s. This is also a political instrument, of course, to protect the ski operators. It's a consequence of big lobbying work after the famous Sunday decision in the middle of the 20th century. I come to a conclusion. Some keywords. I've been thinking the last day about some key questions about the continuation of our workshop, and I would like to deal with them very shortly, and then I will end. First question that arises in this group, I think, is harmonization feasible and desirable, and/or desirable? You know, in the Forum of Bormio on ski issues, we have already raised the question, are we going from different skiing laws to one European skiing law? The diritti della neve to diritto della neve. Secondly, I think on the basis of all the information we have gathered, these sessions and the sessions that will still follow, I think there is a big need for creating a database that could contain legal sources, statistics, but also other issues like, for instance, the mutual recognition of professional qualifications within the European Union, and even with regard to non-EU member states. Thirdly, the actors of the project. How could we involve insurance companies and lawyers and academics together in order to respond to hot issues? Fifth, and fourth, inspiration. I've already mentioned the importance of involving American lawyers, but also lawyers from countries in which issues of personal injury accidents are dealt with in a different way, like in New Zealand, like in the Scandinavian countries. And last but not least, and I asked my students last week, before a group of students last week, I gave this lecture in order to train a little bit, and I asked them about their knowledge of the FIS rules and their knowledge about the insurance coverage, and their answer was very clear. We go to the mountains, and this has to do with what Umberto has told us today. We go to the mountains for partying. Thank you.
Okay.
Yeah, thank you very much, Pieter, for this lively, inspiring presentation. And you opened the discussion for tomorrow morning already, and I pass the word to you.
Okay, so now we have a tea break. We have a small break for tea. It's 5 o'clock, almost. No, it's 4:30. A bit anticipate, not like British style. So we're welcome to have tea, and then we come back here, and I hope that the ICT guy will come here to give this short presentation, and then we will start at 5. Thanks.
Thank you.